last part that we did last week was we finalized the discussion on what is the effect of the Bill of Rights on the common law and on statute. Today we have to move on. So we have, up to now, looked at, in respect of direct application, so park indirect application. That's the values, the spectacles, the shaking it up a bit. Park that for a moment. We've looked at natural persons and juristic persons, and we've determined who gets the protection. And it depends, a natural person always has the protection of the Bill of Rights. A juristic person, it depends on the nature of the juristic person and the nature of the duty imposed by the right. And then we looked specifically at the specific formulations. We've said all children, all citizens, all no one, everyone. You remember those specific textual formulations. And then we've looked at when are juristic persons protected by the provisions of the Bill of Rights. Now, we are asking the question, so who may take this matter to court? And I know that you've looked at this before because your worksheet that you discussed on Monday and Tuesday had a lovely question on standing, which means that you are one ahead of me. So you can go through this relatively quickly. The question that I think was in your worksheet is, what is local standing? What does it mean? What does it refer to? What does local standing refer to? Or standing? Not all at the same time. The enthusiasm is killing me. Anyone? Yes. Shame that you have an unfair advantage, but I can talk to you.
So just because who has the authority to bring the matter to court?
Who is the appropriate person to bring a matter to court? That's the long and the short of standing. Who is the appropriate person to bring the matter before the court? And then what we're going to do today is we're going to look at the contrast between the person who has the right to bring a matter to the court under the common law, and we're going to contrast that with the provisions of Section 38. Because Section 38 is the standing provision of the Constitution which significantly broadens standing under the Constitution. But then we have to bear in mind we're talking about direct application of the Constitution, and that's when we rely on Section 38. When we talk about indirect application, our standing provisions are determined in terms of the common law, and that is why it is important that we distinguish here between standing in terms of the common law and standing under the Constitution. But obviously, what we also know is that the Constitution has an influence even on standing in terms of the common law, and we will talk about Mukadam's case in that regard. Is the person before the court the appropriate person to bring the matter before the court? That's the long and the short of it. So we are talking about the capacity to institute litigation. So does the person have a legally recognized interest in the action before the court? So in other words, is the person who is before the court the person who will benefit from the remedy that is sought from the court and that the court will make? So this particular matter, and remember when we talk about standing, we're talking about a particular matter that is determined by a court. And what is the second important thing that we have to bear in mind is that standing is an in limine determination. What is that? If we say that something is in limine, what is the Latin word for a suit, a legal suit, not a suit, a legal suit? Lis. Okay, and you should be able, with your vast knowledge of Latin, you should be able to get from lis to limine. Pending the legal proceedings. So it's pending the proceedings. That is what in limine means. Pending the proceedings. So the bottom line is, you have to establish standing first before you can continue with the matter. So if you come to court and you say, you would like to sue X, and X says, but you don't have standing. You are not the appropriate person to bring this matter before the court. The court will determine that matter and then decide whether you have standing or not. And guess what? If you don't have standing, what then? It's the end of the matter. So it is an eliminate determination, and the court, if standing is contested, will make a determination, and it may continue with the matter, but if at the end it finds that you don't have standing, that's the end of the matter. So it's important to bear in mind that this typically is one of the things that people challenge as part of their strategy in litigation. So if I am the lawyer for the respondent or the defendant, I'm going to say, but who are you, applicant plaintiff, to bring the matter before the court? You do not have an interest in the matter before the court. I'm contesting the fact that you have standing. Then you have to assert standing, either if your complaint or your claim is in terms of the common law or in terms of the provisions of the Constitution. So it is a matter that is dealt with before the court deals with the merits of the case. And typically, when it is contested, that is when the court will make significant pronouncements about standing. But where the court is not dealing with a contestation regarding standing, it is assumed that the person defending the action is satisfied on the papers that the person indeed has a right and is the appropriate person to bring the matter before the court. But I think we're going to contrast the provisions of for standing under the common law with the provisions for standing under the Constitution. Now, the common law, as it existed prior to 1994, prior to the breach of the Constitution, had a very narrow approach to standing. So, it has to be, it must have been, it should have been my right. So, I go to court, I have to show to the court that it is my right that has been infringed, and I have an interest in the remedy. So, the person must approach the court, must have a sufficient, and these were the causal, the crux determinations, a sufficient and direct interest in the subject matter of the litigation. A sufficient and direct interest in the subject matter of the litigation. And the person must have been personally adversely affected. So if I want to bring a suit under the common law to the court, I have to say, I was defamed, or you breached the contract, and therefore I suffered damages. So I have to show that it is me that is affected by the unlawful actions on the part of the defendant respondent. So I have to show a sufficient and direct interest in the subject matter of the litigation, which is, we had a contract, you were going to deliver in terms of the contract, you didn't deliver in terms of the contract. Because you didn't deliver in terms of the contract, I couldn't carry out my responsibilities, so I suffered damages. I have a sufficient and direct interest in the subject matter of the litigation, and then, as a result of you not complying with the terms of the contract, I was personally adversely affected. I personally suffered damage. Breach of contract is a very good example, and A defames B is a very good example as well. So in this instance, for example, if A was defamed by B, can X institute proceedings against B? I think it seems fairly obvious. It's quite logical to say that if you have been defamed, what does that mean? If you suffer damages as a result of the breach of a contract, can I go to court because you suffer damages? No. So because it has to be the person who was personally adversely affected with a sufficient and direct interest in the subject matter of the litigation before the court. If you suffer damages, it's nothing of mine. Okay, so that's an important distinction that we have to bear in mind, that the common law in particular requires this fairly close nexus between the subject matter of the litigation and the person bringing the matter before the court. But that's not hard to see, because you can easily see that if it is I who suffer damages, I am the person who can institute proceedings. We're not talking about session and just leave that aside for the moment. We're talking simply about direct sufficient interest, and we're talking about personal adverse effect. And that's fairly straightforward. But when it comes to human rights, how do we engage the court when we talk about matters pertaining to the protection of human rights? Okay. If children are denied admission to a local primary school, or if children are denied access to basic health care services, who may litigate on the basis of that? Who may do that? The children? But do children have the right to engage in matters before the court? Do they bring matters in their own name before the court? They must be supported by parents or guardians. Okay. So the children could, if I'm the NGO and I'm concerned about education, does equal education have anything to do with it? The Children's Legal Center. Who are they? What are they? Busybodies poking their noses in business that's got nothing to do with it, because it's not their children. Is it in society's interest that children get access to quality education and healthcare services? Yes. So if I'm a member of society and I see, oh hell, things are going down the tubes here, I have to do something about it. In certain instances, the Constitution recognizes that these are matters bigger than just those children and their parents. These are matters significantly bigger that actually affects more. The second requirement, the second example. A statute allegedly discriminates unfairly against non-citizens who are permanent residents by excluding them from certain benefits. So certain permanent residents do not have the same benefits as citizens, even though they pay taxes, they contribute to society, X, Y, Z, A, B, C. How can we deal with that? Who is the appropriate person? Must it be a citizen, one of those permanent residents? And if that permanent resident is a group of, as a member of a group of 50,000 people, must each of the 50,000 permanent residents bring their own matter to the court? No, because it's going to take an inordinate amount of resources and time to get through the 50,000 matters. So the Constitution devised a mechanism where we can deal with similar cases at the same time. An international company obtains a mining prospecting license to extract minerals from a beach situated in a natural conservation area, which will invariably disrupt the ecosystem in the area. Who can take the matter to court? Must it be someone who lives close to the beach? Can it be environmental warriors for the Eastern Cape pristine beaches? On what basis? What interest do they have? Can you see we're talking about very different kinds of matters under the Constitution? Because if it is me who suffers damage as a result of the breach of a contract, that line can be drawn very clearly. From me to the damages to the contract to you. Easy peasy, lemon squeezy. However, if it is an international company, and I'm saying the minister, the Department of Minerals, Mining, they have granted this prospecting license despite the fact that everything points to it. Can I do that on my own? Must I be a part of the member of the community affected? How does it work? So we are talking about very different ways of engaging because rights of people protected in the Constitution affect those particular people the children who can't go to school, the permanent residents who can't get the benefits, and the general public. But how are we going to set up measures to ensure that the rights that are set out in the Constitution are not merely on paper, but that they actually mean something? Okay. So, what does the Constitution say? And this is the text of the Constitution, so please don't write this down, because then we'll be here until tomorrow. Okay. Section 38, and it helps if you look at Section 38 and you read the most important parts and emphasize, underline them for yourself. Anyone, okay, that's quite clear. grant appropriate relief, including a declaration of right. The persons who may approach the court are anyone acting in their own interest. That's easy, isn't it? Because I can say the statute or that governmental action infringed this particular right of mine, and therefore I should be granted access to court and I should be granted the relief that I seek. Anyone acting on behalf of another person who cannot act in their own name. If we think back of the school children, let's make them people without any parents. Let's make them members of child-headed households. Where are they going to find someone to support them? If I am a social worker or a teacher or a member of a non-governmental organization that has the best interest of members of my community at heart, then I can approach the court on behalf of people who cannot act in their own name. And then C and D are where we're going to put our focus because those are the challenging ones. Anyone acting as a member or in the interest of a group or a class of persons. Remember we spoke about the foreign nationals, the permanent residents who are not able to get certain benefits. 50,000 of them. How do we get that matter before the court? And who decides which of the 50,000 matters are decided in a particular way and which of the 50,000 are not decided in a particular way? How do we deal with that on a very practical level? And then the busybody who presumably has lots of time to poke his or her nose into other people's business. Anyone acting in the public interest. If you go back to our example of the environment, if I am a member of an association that works tirelessly to protect the environment and make sure that all the legislation pertaining to the protection of the environment, that is actually enforced, I can say, well, actually, keeping this beach pristine or keeping the ecosystem intact is something that is in the interest of all of us. How do we determine whether I am just a busybody or whether I'm genuinely acting in the public interest? So we are going to focus much of our emphasis on categories C and D. And if I ask you a question, in all likelihood, there will be C or D question. The C or D is far more interesting than A or E, and perhaps B. But, B is also interesting. Okay. And then an association acting in the interests of its members. This is also very significant because at common law, it was only if the association had certain characteristics that the association could enter into litigation. So the members of the Legal Theory 2 class of Rhodes University of 2018 couldn't really litigate on its own. But if we form an association, we could assert standing under Section 318. But at common law, we would have had to establish a separate legal entity, which we are not. Because we're not going to set up a company. We're just going to say, okay, guys, who's in the association? Sure, okay. Bob's your auntie. Who's the chair? Who's the secretary? Let's move on. So it broadens the scope in relation to standing very significantly. Okay, now, what we have seen from the case law, and you will see that the cases here, once again, are older cases. And the reason why is this was when the principles were established. Now we simply argue about the application of the principles. If our fundamental rights, the court in Ferreira's case made it very clear that we cannot have the narrow common law approach to standing. Because if we want the Bill of Rights and the Constitution to be more than merely the pieces of paper that they are printed upon, people must be able to rely on those rights and test those rights. If they can't, then why do we have this? If we have human rights and we are not in a position to ensure that our courts consider cases based on the Bill of Rights, what does the Bill of Rights mean for us? Very little. Because we are not in a position to make sure that our rights are protected. So it's very important that the court acknowledge the importance of a broad approach to standing. And obviously in Ferreira's case, you can imagine what matter was brought before the court, and there was an assertion on the part of the respondents, you don't have standing. Because what is the right that you are alleging has been infringed? And what is the interest in the remedy that you seek? And the court said, if we were to take the narrow approach under the common law, and we want that direct, sufficient interest, the link between me and the respondent and the legal action, well, obviously, we're going to say it's too tenuous. But if we acknowledge that we need ventilation of the Bill of Rights, we need litigation on the rights in the Bill of Rights, then we acknowledge that we have to have a broad approach. Now, then the court goes on here to say that Section 38 requires two basic things. And if we go back to the text, and I've highlighted things, let's go back to the text. An allegation that a right in the Bill of Rights has been infringed and sufficient interest in the remedy. So, Ferreira's case tells us that there must be two requirements. Now, I've set out here the facts. It's not very important for our purposes to see what the facts are. But what we do know is that the court asserted a broad approach to standing. There was a challenge to the Companies Act. The Companies Act required certain people to divulge information, and the people who were then questioned in terms of the Companies Act said, but this infringes upon our rights. And the courts, first of all, Judge Ackerman said, which rights? They said the right to be presumed innocent and the right to a fair trial. He said, you're not accused persons. Only accused persons are entitled to those rights. You don't have standing. Accordingly, the court had to take the majority of the court, by Martin Chaskelson, and then Reagan's very important contribution is here, that we cannot have a narrow approach to standing. If we have a narrow approach to standing, we close down conversations around application and protection provided by the Bill of Rights. And we need to open it up. Okay, so what we have here is that the court identified the two requirements very clearly. There must be an allegation that a right has been infringed, and the applicants, they don't have to can, but they must show a sufficient interest in the remedy that they seek with reference to the categories in Section 38. Okay, we're going to go through this very clearly and slowly again. So in order for me to assert standing on the basis of the alleged infringement of a right in the Bill of Rights, I have to go to court and I have to say, I am me, I am acting in the public interest. I would like to bring this matter in the public interest to the attention of the court so that the court can grant that remedy. The public has an interest in that remedy. Or I have to say, this is me, I am a social worker. It came to my attention that these elderly people are being denied their pensions, their old age grants, by the particular officials in whatever SASSA office, and I would like to bring that to the court's attention. The reason why I'm bringing this matter is because it's impossible for them to get to court. They are bedridden, some of them are not capable of managing their own affairs. So I'm bringing this matter on behalf of those people who are incapable of doing it. And I want you, court, to make an order to get the SASSA office to actually pay out the pensions as they are supposed to be doing. Okay, so it's very important that we look very systematically at what the two requirements are. But before we go to the two requirements, one of the things that I want you to bear in mind as you go through the cases, you cannot go to court with a hypothetical or an academic question. So if what you want to know the legal position about is something that is interesting, but it's not a real concrete live problem, that requires the court to grant a remedy based on the allegation of the infringement of the right and the demonstration of sufficient interest in the remedy that you seek, the court will say this is simply a hypothetical or academic case. and we're not going to grant you standing. Because you have to assert that the matter before the court is not merely academic. It has to be a real matter. If you read the case of giant concerts, you will see how the court understands and construes this idea of something that is merely interesting and potentially could have an effect, but it doesn't really have an effect. Okay. So, let's look at the two requirements. And if you get a question, and I think I've said it about 500 times, but I will say it again, and I've never said it in this class, so let me say it for the first time in this class, and then you can say it for the next 499 times over the next couple of weeks. If you get asked a question, and typically a question on standing starts with, you are consulted by A, B, C. Who is A? Who wants to know whether they will have standing, or who will have standing? You start at the very beginning to say, in order to determine who has standing under the Bill of Rights, two things are required. An allegation that a right in the Bill of Rights has been infringed, and the applicants must demonstrate sufficient interest in the remedy that they seek with reference to the categories in Section 38. And I've already told you, we're focusing on C and D. Okay. So you have to say, first of all, if I give you a long, convoluted story, it's always a long and convoluted story that I have to think about in the next 2 weeks. If I think about my long and convoluted story, you have to identify the right in question. Okay? So you have to say, Johnny has to say the right to freedom of movement. He alleges the right to freedom of movement was infringed. And Johnny has an interest in the declaration of invalidity because personally, this, that, and another thing. Or as a member of a group, or as this or that, as a member of an association, or the protection of the environment, or whatever the case may be. But you have to start with those two general requirements. And let's look at those general requirements in more detail. First of all, it must be an allegation. At this point in time, because we are talking about an in limine determination, you don't have to prove anything. You have to make an allegation. Here I am, my right to freedom of movement has been infringed, or is infringed, or is threatened by this statute, or by this common law provision, or by that governmental action. Okay. So you have to indicate that it's in the past, your right was infringed, your right will be infringed, and this is important because you don't have to wait until your right has been infringed. Because if you look at the text of the Constitution, it says an allegation that the right has been infringed or threatened. So if I know that the proverbial is going to hit the fan fairly soon, I don't have to wait for the fan to be ruined. I can go to court and I can say, I'm seeing that pawpaw coming. Can we stop? Okay. So you are allowed to have a preemptive strike. So you don't have to wait until the right was infringed. You can actually approach the court with a request that the court takes action, the court grants a remedy to prevent the right from being infringed. But we're very important here. We are talking about a right in the Bill of Rights. We are not talking about my rights in terms of a contract. Because if you and I conclude a contract, what is the legal instrument that gives rise to the rights coming into existence? The contract. But we are talking about the rights that you and I are granted under the Constitution. So if I want to rely on Section 38, I must know that my case is actually one that involves the protection and upholding of Section 38 of the Bill of Rights, relying on Section 38. Okay. So, the last point going to court, I'm a social worker, or I'm the chairperson of an NGO, I'm equal education, I would like to protect the rights of the children. Clearly, those are not my rights, but they're the rights of children, but I'm acting in the public interest, or I'm acting on behalf of people who cannot act in their own name. Okay. So it's not necessarily my right, which you can see broadens the protection of the scope, rather, of the protection of the Bill of Rights significantly. Because we're not talking about my right only. Whereas when we talk about common law standing, typically it's my right. And here we are talking about something far wider than the protection of only my own. So, the second requirement is that you must show sufficient interest in the remedy that you seek from the court. And how do you do that? You refer to the categories set out in Section 38 to demonstrate sufficient interest. But it's very important for us to bear in mind that there's no clear test. So we can't say the following three factors are the factors that will determine whether the court will find that the person has standing in his own name or so. You have to look at the facts of the particular case, and you have to determine whether there's a sufficient link between the remedy and the categories that are listed in Section 38. And this is quite important, because you have to assert standing in order to proceed with your matter. And what is further important is that you don't have to tick all the boxes. Section 38 is not a tick box exercise. If I so happen to have my own right infringed or threatened by a particular statute, I have a certain standing in my own name. But if I know that I'm one of 10,000 people in the Eastern Cape in exactly the same position, I can also take the matter and assert standing in my own name, but also in the interest of a group or class of people. Okay? But you don't have to tick all 5 boxes. If you've asserted standing on one ground, you've asserted standing. That's it. But typically, the remedy strikes wider when the remedy has repercussions for an entire group of people, as opposed to just for me. And if I go, because my pension wasn't paid out, to court, and I obtain an order that the Department of Social Welfare, that they have to look into it and ensure that my pension is paid out, who gets the benefit? What? But what about the 10,000 other people in the same boat? They have to take their 10,000 cases, one by one, or someone can say, well, guys, who's got the same kind of problem that I have? Let's just bundle these together. And then what are the requirements in that regard? That's what we're going to unpack in the next 2 lectures. And I want to get through A and B today, because A and B are easy. And then tomorrow, I want to ask you to read Musa's case, but we'll get to Musa just now. Let's start with the easy stuff. The easy stuff is a person acting in his or her own name. So I'm going to go to court. I say, court, I would like to have a declaration of invalidity of this legislation because it discriminates unfairly against me. Okay? So that is my allegation that I take to the court. And I must show that I have a sufficient interest in that remedy, based on the allegations that I make regarding why this is unconstitutional or whatever the case may be. But I have to draw a link between what I'm asking of the court and my right under the Bill of Rights. So I start by saying, my allegation is that the right that I have under Section 10 or the right that I have under Section 12, that right is infringed. And I want you, court, to grant me a remedy, and this is the link between me and the remedy and the right that I seek from you. So you have to draw that link for the court. So you simply, and this is very similar to the common law narrow approach to standing, you have to allege that a particular right of yours has been infringed and that you have an interest in the remedy of a declaration of invalidity or constitutional damages, or a declaration of rights, or whatever the constitutional remedy is that you are asking the court for. But you have to draw that link between yourself, the right, the remedy. The person before the court is the appropriate person to bring the matter before the court, because that person alleges that a particular right has been infringed, and that person has an interest in that particular constitutional remedy. Clear as daylight, eh? Easy. Now, you will see that in the textbook there is a example of Janssen van Rensburg, and in this particular case, the court considered the whole notion of having to wait or not for a right to be infringed. The court said the text is fairly clear. A right that is threatened entitles a person to stand. You don't have to wait until that time that your right is infringed. If you can see or foresee, as a result of X, Y, Z governmental action or statute or whatever the case may be, your right will be infringed, you can take preemptive action to prevent the infringement of the right. Okay, the second category that I want to look at today is a person acting on behalf of another person. Okay, a person acting on behalf of another person. Now, the important thing here is that adults, majors, people over the age of 18, litigate in their own name. So you're 18 years old, you litigate in your own name, you don't need the permission of your parents, you don't need anyone's permission, you litigate. There's a presumption, as you should know, that we are all of sound mind, which means that unless someone can challenge that, we can litigate in our own name. So when we are talking about people who are unable to act in their own name, we are talking about people who either would have given consent, or people who would have given consent were they able to. We are talking about people who are not able to litigate in their own name because they are detained, because they are old and frail, because they are children and they don't have standing in their own name. They don't have the right to stand unassisted in a court of law. Children can litigate, but they must be assisted. But the important thing that we must bear in mind here is that the person must consent, or it must have been evident that the person would have consented had that person the opportunity to be asked whether he or she would consent. So when you're talking about detained people, for example, it's impossible for me to gain access to the prison because the people are locked away and the key's been thrown in the sea. But I know, had I had the opportunity to consult them, they would have said, go for it, get us out of here. They would have consented. Or if we're talking about children, clearly they are not in a position to make their own decision. And I can go to court saying I'm acting in the interest of this group of people, or this child who cannot act in their own name, or old people, or whatever the case may be. But it is evident that the person must have consented, or that the person would have consented if they could be asked for their consent. Now, the very important thing here is, I, as the litigant, do not have the interest in the remedy. The person who I am acting in the interest of, that person has the interest in the remedy. Okay. So I must show that this child who's been denied access to health care, but who is unable to act in his own name, I'm acting on behalf of the child. The child has the interest in the health care. Not me, the child, or the old person, or the detained person, or the ill person. That person has the interest in the remedy. Okay. Now, what do I want you to do for tomorrow? I know you're studying for persons because I will see you. But the show must go on. I want you to read Musa, and I'm going to show you the reference, and we will go through this consistently or systematically tomorrow. Musa and others versus Permanent Secretary, Department of Welfare. locus classicus on class actions. And unfortunately, we're 18 years down the track. We don't have rules. We don't have legislation regulating this. So for the greater part, when we worry or think about class action, we have to go back to User's case. So I want you to go and read User's case carefully. It's not a very long judgment. And if you want to enlighten yourself beautifully, you would also read the ACA judgment, because Judge Cameron was an ACA judge at the time, and he actually wrote quite a scathing judgment on the actions of the Eastern Cape Provincial Government Department of Law and the actions of being at war with its own citizens. So I want you to go and read those two judgments so that you can see why is it appropriate and when is it appropriate and how do we determine who is in and who is out. Okay, I'll see you bright and early tomorrow morning.